Welcome to Continental Divide, a guide to Colorado divorce.
Hello, everyone, and welcome back to Continental Divide, a guide to Colorado divorce with Kristi Anderson-Wells of Wells Family Law in Denver, Colorado. A former executive compensation attorney and author of the Executive Compensation Handbook published by the American Bar Association, Kristi brings a unique perspective to divorce, complex finances, parenting, and problem solving in Colorado family law. I'm Sean O'Connor, and today Kristi and I are talking about dividing stock options, RSUs, and executive compensation in a Colorado divorce. Hello, Kristi.
Hi, Sean.
Why do stock options and RSUs and all the deferred comp create so much confusion once a divorce starts?
So first of all, stock rights, executive compensation, a lot of it is about owning a piece of the company, giving executives an incentive to drive up stock prices. And so it's sometimes it can be one of the biggest parts of an estate. If I'm doing a tech divorce, there could be millions in stock rights.
Right.
Even small companies will give stock rights as an incentive for their C-suite executives or even their rank and file to be pushing to increase the value of the company. And because it can form such a large part of the marital estate, there's a lot of weight put on it. And then we've got some weird law in Colorado that makes it kind of confusing. So
Well, I don't know if having, had a real job before, like some of those documents just are confusing, to say nothing about the fact, you're talking about pinning stock, compensation to stock value, and, things are up and down in terms of, well, today I'm a millionaire, but tomorrow I might not be a millionaire on paper, right?
especially if you own NVIDIA, who knows where we are. Well, here's the thing, in the United States, we have sort of this weird retirement system. So we've got regular retirement. You would envision it as an IRA, a 401k, or maybe a pension. Pensions are easing out, but these are all qualified plans where the Internal Revenue Code makes it so that whatever goes into those plans or whatever's growing in those plans for your benefit is not going to be taxed until it comes out.
Right.
On the other hand, and those plans are subject to non-discrimination testing, so that really the high muckety-mucks, the C-suite executives, can't take advantage of those plans to enrich themselves.
Right.
So, and there's caps on how much that can be contributed, how much.
It's all very regulated and also
regulated.
transparent and relatively predictable.
And executive compensation is more like the Wild West. It's really like, well, let me see if I can give you a little history. Do you remember Enron in the 2000s?
Of course,
That was 26 years ago. So Enron was I think it was a natural gas company, and they grew really rapidly, and they did some fancy footwork with their books. And their stock price got up to like almost $100 a share when suddenly it was discovered that their books were cooked. And the stock price dropped to like $1 a share. 25,000 employees lost their jobs. And the rank and file employees had been heavily invested and encouraged to invest in stock of the company in their 401k. So those rank and file employees were left with no retirement. The executives, on the other hand, knowing that, the fall was happening, they took their executive compensation packages and they distributed to themselves. So they got their money out. I'm not going to mention names, but a lot of them were prosecuted for what they did.
I said, you can find it on the web.
You can. And we got a lot out of that. We got Sarbanes-Oxley, which was some regulations, and we got a code section called 409A. And what that did was it basically said executive compensation is going to be subject to limitations, and executives are not going to be able to accelerate taking their money out of these plans except under very certain limited circumstances. And those circumstances are, well, if I've got stock rights out there vesting and I become disabled, maybe the plan can provide for me to accelerate my benefits. Or if I retire, or if there's a change in control of the company, there are these circumstances where executives can accelerate their benefits. Super complicated, but basically it's created a weird situation where we know in divorce that qualified retirement, 401k, whatever's vested is going to be divided. In the pension, whatever's vested is going to be divided. In the IRA, whatever's vested is going to be divided. But in executive compensation, vesting in Colorado means nothing because you could have a plan that says, well, these stock options are going to vest over 4 years, but you could also get them in the 4 years if you retire or become disabled or there's a change in control. So people get really confused. First of all, a lot of executives don't know what they have. They don't understand their plans or their awards. And then you've got the fact that vesting doesn't mean anything. So Colorado's got some law that says you have to look really closely at those plans and those awards, and you have to figure out if there's a way for that benefit that's still supposed to be vesting for you to get it early. If you can get it early before the vesting period, then it's property to be divided in the divorce. If you can't, so let's say the plan says you have to be employed on the last day of the vesting period in order to get it, then it's not property until it vests. And this is where people just cannot figure it out. Courts can't figure it out. Executives can't figure it out. People just get very, very confused.
Yeah.
And
Yeah.
and those plans, as you said, not easy to read to begin with. Some of them, I think they do it on purpose.
Well,
I mean, I used to draft those plans,
right. I
and
was
I
going to say,
swear
that's a lot coming from you.
I didn't mean to make them obscure, but
Right.
they are kind of
Well,
obscure.
are there any distinctions that you think are important to make between, options versus restricted stocks versus the RSUs versus, phantom stocks? Are you kidding me? Yeah.
So the first thing is, I have to say, is if you're looking at qualified plans, they have a lot of the same provisions.
Yeah.
And we know what they mean, right? Because it's laid out in the Internal Revenue Code. Executive compensation, the only guarantee I can give you is every single plan is different. Every award is different, and they can define things in ways that don't make any sense. So when I tell you now that I can tell you the difference between restricted stock and restricted stock units, I have a general idea, but until I look at the plan, I'm really not sure what we're talking about. In general, though,
Yeah.
restricted stock, if I get an award of restricted stock, I'm getting the stock. If you think about how it was maybe 40 years ago when you would actually get a stock certificate and it said 1 share of
Yeah.
GE, I get the stock, but it would be endorsed to say you cannot transfer this stock for 4 years. And
Right.
that's your vesting period. That's restricted stock. It's stock that I own. I get the benefit of the stock, and I am not allowed to transfer it until the vesting period is over. Restricted stock units, well, they can be a lot of different things. They can be like options. That is, we're giving you a sort of a make-believe unit that will rise in value during the period of vesting. And when it vests, we'll either pay it out in stock or we'll pay it out in cash. But during the period of vesting, you cannot transfer this unit. It's a make-believe. It's not a piece of paper. It's conceptually different in that you don't have control over the stock. Often in restricted stock, you'll get dividends or you'll get, I don't know. There's stock rights that come with owning the
Right.
stock that you wouldn't have with units. Stock options are an option to purchase stock in the future at the present value, generally. And some of them require that you come up with money. So I may get a stock option today. Value of my stock is $10. In 4 years at the end of the vesting period, the value is $100. But I have to show up with the $10 in order to exercise my option. So that's kind of just tracking the increase
Yeah.
in value. And you can see why the equity interest, it's going to trigger your executive or your stock option holder to work harder to increase the value of the stock. The more they work hard for the company, the more they increase the value, the more the payout at the end of the day.
Yeah.
Phantom stock, very similar. It's like a ghost. You're tracking an entry that is saying, this is the value of stock.
Yeah.
On today's date, this is the value today. Now we're going to pay you out the difference. There's a lot of different things. I've seen them called a lot of different things. But until you look at the plan and until you look at the award, you can't really tell what you have. Some stock rights vest just over time. And
Yeah.
some stock rights vest because you've achieved certain
You hit
parameters.
you hit a benchmark of some kind, right?
Right.
Well, if
And
I was,
so you can't tell till you see the documents.
yeah. I was curious, like, why do stock right disputes become so difficult? And it's like, well, what do you mean? Why? I mean, how could they not be? Or is there something in Colorado that adds a layer of complexity? I mean, I know states are different.
I think our law actually tracks it pretty well. I think that the Supreme Court got it right. So basically, what the Supreme Court is saying tracks with a bunch of other law. And what the Supreme Court is saying
Colorado's
is
Supreme Court.
Colorado Supreme Court is
Right.
they're saying we're looking at how much work you did during the marriage to get this. So if you're saying, I have a 4-year vesting period and I don't get anything, there's no property right unless I'm employed on the last day, and we're getting divorced in the middle of that period. If I can't get it until the last day and we're getting divorced halfway through that period, there's no property to divide. I think
Yeah.
they got that right.
Yeah.
But if it's a plan that says, well, I could get it tomorrow if I retire or if I'm disabled, we've got law that says, the existence of those rights means that I don't have to perform any further services in order to get it. Like right now, I've got an enforceable right to that property, even though I haven't died or become disabled, or
Right.
I still have a legally enforceable right. So conceptually, I think they got it right.
Let me ask you this, Kristi, okay, I'm going through a divorce. It's as amicable as it can be. And this stock option vesting situation, I'm not going to get it if I cash it out now, whatever, right? Do the parties ever come to an agreement whereby, like, that'll be something I will pay you at a future date because I am going to retire from this company eventually, and at that point I owe you this X amount of money? Or is that messy? And
No, I think I think where you're going is if there's property. We don't know right now whether the stock, like for instance, on an option, is going to be, the value of that stock is going to be higher than on the date it was granted, or if it's going to be lower. So we don't know if that property right is going to have any value on the date that it's exercisable. And I hear what you're saying is, is it worth just saying, hey, we'll divide it now, and whatever it is on the date it gets paid, that's what we divide. If it's 100% increase, we'll divide the 100% increase. If it's gone down, well, then neither of us gets anything. We're sharing the risk up or down.
yeah.
Lots of cases get settled that way. And it's a lot smarter, really, than paying the money to a valuation expert to try and figure out what the value of stock options are. I mean, most of those valuation experts will tell you there's so many variables that they have to look at to value a stock option. And, there's as good a chance they're going to be wrong on the value as they're going to be right. So it makes a lot of sense in divorce cases to say, we'll divide it if, as and when it becomes vested. I mean, that's the smart way to look at it.
Yeah. Otherwise you're asking the quote unquote expert to be a stock picker, so to speak, right? Like, oh,
right. I mean, there's too many variables. I think this is getting so technical, no one's going to want to hear it. But I mean, the Black-Scholes method for valuing stock options, there are so many variables. It's just, if you look at the variables, you'll just say, how can I possibly get this right? I don't know. Luckily, I don't have to value stock options.
Right, yeah.
My job is easy.
Are there details inside these compensation plans or employment agreements that end up changing the outcome of these cases, like certain ones that, like, in advance that's going to be a problem or a challenge, or are they all sort of created equal in terms of complexity?
No, you would be surprised at the interesting things that show up in these plans. Some plans, you think you've got something, you're reading through it and you're like, oh, this is amazing. It vests over 4 years and it's going to have so much value. And then you look at it closer and you realize, well, there's like a third trigger. And the third trigger is that the company has to go public in order for any of this to become anything. And it's in a tiny little sentence at the very end.
Yeah, by the way.
And so you're thinking, oh, this is great. There's so much property here. And then you realize a company hasn't gone public and there's nobody even discussing.
Yeah, and the markets are a mess and it's not a good time to go public,
exactly.
etc., right? Like,
so, and sometimes, you have to read all of them. Sometimes they're really long. You have to read all of it because you'll find that at the very end, or it's in some obscure portion of the award agreement. And
Mm-hmm.
companies do all sorts of amazing things to
Yep.
incentivize the things they want to receive from their executives.
Golden handcuffs, I believe, is one of the
Exactly. Keep them
expressions.
there and keep them working.
Yeah. Well, I mean, I don't know if this will be a practical exercise exactly, but, for listeners out there, what mistakes should people watch out for that create the biggest financial problems later? When executives or high income professionals try to handle these issues too casually. Like at the beginning, everything's hunky dory, right? We were talking with your colleague Ann the other day, and it's like, oh, everything is great until it's not. So are there mistakes people should be cautious of, just to not put their foot in it, so to speak?
Well, I mean, here's the funny part is a lot of times people will call me like the week before mediation and say, I didn't think there was anything here because it wasn't vested. So number one,
Hmm.
it just don't hang your hat on vesting. Figure it out. Figure out if there's property there or if it's just a mere expectancy. That's number one. The other thing is don't hang all your hat on it being property. In Colorado, the statutes require that we first divide the property, and then we look at what maintenance will be based on the income that the receiving, party is going to receive off the property that they get.
Yeah.
So maybe they get a big award of the wife's stock rights, right? And that's going to vest ratably over time, and they can expect to receive money from that. Great. That's going to reduce the amount of maintenance they're going to receive, though, in the husband's, maintenance request, because he's going to now have money coming in.
Yep.
So if you hang your hat on, is it property or is it not property? And then you get really disappointed. I mean, I often represent the moneyed spouse, and the moneyed spouse doesn't want it to be property. But the good attorneys that I work with will say, look, we're either going to divide it as property or it's going to be income for maintenance purposes. So don't get too hung up on one or the other.
Mm.
To the extent it's not divided as property, it's going to be income. And then you get to make the argument that, hey, that person has either enough of their own income because we divided the property, or they, there's going to be a lot of income for them to receive as maintenance. So
Hmm.
I think looking at it just from one perspective can be a big mistake.
Yeah. My answer would be, call an attorney for because it is. I am interested in this topic, and it's confusing, and like you said earlier, even the executive, male or female, with when you're getting your like, am I getting paid enough? Okay, good. I'm not going to worry about the what's in that fine print yet until again something happens.
They don't read it. They don't.
Right.
And you know what? Even the smartest executives, the very top,
Yeah.
they don't know what their compensation package says. They really don't. And sometimes, I'll have someone on one side of a case going, they're not giving us what we need. They're doing it on purpose. And I'm like, they don't even know.
Yeah.
They don't know what documents you need. Let's just call the benefits department. We'll set up a call. We'll get the documents from someone who knows
They'll
what the
authorize,
documents are.
send this to my attorney. Yeah.
Yeah.
Kristi, we're up against time, but
Again? Oh, Sean.
the clock ticks. It's like being at the therapist here. It's like a 50-minute hour.
Well, as long as we throw the word sexy in, I know it's going to be a big seller.
Absolutely. I'm with you on that one. Great to talk to you.
Great talking to you, Sean.
That's it for today's episode of Continental Divide, a guide to Colorado divorce. If you'd like to learn more about Kristi Anderson Wells and her team at Wells Family Law, visit their website, wellsfamilylawcolorado.com. Thanks for listening, and as always, do us a favor, subscribe, leave a review, maybe share a link with someone in your world who needs some help with family law matters. That's always super helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.